Good morning once again, and thank you for waking up and staying tuned to Sunrise at Sea here on CTV. Welcome to Twitter Jabs 2. My name is Agi Uwase, and we are continuing the conversation in regard to bail practices in Uganda. And this comes at a time when the former Forum for Democratic Change, and that is Dr. Besigye, was released, and also his bail terms eased from 30 million Uganda shillings to 3 million Uganda shillings. And definitely this sent, tongues wagging on social media, people talking about how appropriate is this, how does this come about, and people definitely left in a state of confusion and definitely asking for answers. But joining me at the center of this conversation today to give us insight on exactly who deserves to get bail in this country, the terms and everything that is involved when it comes to bail, is none other than Counsel Eric Namungalu, who is a human rights and constitutional lawyer. Good morning, sir, and thank you for coming to Sunrise at Sea this morning.
Good morning, Agi.
Well, for my first question, I'd like to ask you, in regard to bail practices in Uganda, who deserves to get bail?
Well, every Ugandan deserves to get bail. The right to apply for bail is a constitutional right under our constitution.
Yes.
So everyone has the right to apply for bail, and therefore everyone has the right to be given bail by courts if they meet the requirements set by court.
Okay, and in regard to what happened to Dr. Besigye, his bail terms being eased from 30 million to 3 million Uganda shillings, would like to, give an insight to the viewer out there. How does this come about? Is it actually appropriate?
Yeah, in regard to Dr. Besigye, he was granted bail by the magistrate's court and given a bail bond of 30 million shillings as security. And he felt that was excessive, so he ran to the High Court asking for the court to revise the decision of the Chief Magistrate's Court. And whereas the court didn't revise the decision, they thought they had the power under the Magistrate's Court to vary the terms of bail.
Yes.
So court agreed with Dr. Besigye that indeed 30 million seemed to be excessive given the nature of the offense, as well as the fact that colleagues he had been arrested with in the same case had received much lighter bail terms. So court varied the bail terms and reduced it from 30 million to 3 million shillings.
Okay, and speaking constitutionally, what informs these bail terms?
What informs these bail terms is actually a matter of really a matter of courts, because bail in Uganda is discretionary for court, whereas you have the right to apply for it, but the discretion to grant bail remains with court. So when you appear before court, court will look at a number of things. We look at the nature of the offense you're being charged with, the kind of punishment it carries. They'll look at the kind of person you are, whether or not there is a history of you jumping bail. Then they'll look at whether or not you have permanent residence in Uganda. And then, based on those considerations, court will go ahead to grant you bail if you meet those considerations. So they'll grant you bail and ask for sureties as well as security in many cases, which may be either cash or any other substance of value like a land title or anything of that nature. So as long as you meet those terms that court has set, then court will grant you bail.
Okay.
Yeah.
Now, Honorable Arias Lukwago is also among the lawyers of Dr. Besigye. They talk about even after easing the bail terms from 30 million to 3 million Uganda shillings, they said even this one is still too much for the offense that Dr. Besigye committed. What would you say about that?
I mean, I can't disagree with Honorable Arias Lukwago.
Yes.
Really, this is a matter of fact. How much money should be set as security for bail is a matter of fact. But maybe was relying on past decisions, because we have a decision of court where journalists were arrested and they applied for bail and they were granted bail and they were supposed to deposit about 1.6 million shillings. Although that case is a bit older, more than 10 years ago.
Yes.
But court thought at the time 1.6 million was actually excessive. So in these circumstances, 3 million shillings, if someone says it was excessive,
yes,
there's not, you can't totally disagree with them. It is possible that it's excessive.
Yes.
Yeah.
And also in regard to that, because multiple Ugandans from back in, I'll actually talk about some of the leaders in the opposition party who until this day are still, you know, locked up and they haven't been granted the bail that they have been applying for. So Ugandans on social media are talking about how does it come so fast for Dr. Kizza Besigye, whereas some of the opposition party leaders, especially from the NUP party, haven't yet been granted bail. So it comes off like the law is actually selective.
Well, I really can't speak that much for the judiciary, but what I can say is, like I noted earlier, bail is discretionary for court. And the circumstances under which bail will be granted are different. For instance, if we're talking about the magistrate's court, if you're charged with an offense that is triable by the magistrate's court, the conditions for bail actually are a bit lower than if you're charged with an offense that is triable by only the High Court. The terms of bail may be a bit higher because if you're tried for an offense that is triable by the High Court alone, you actually have to prove exceptional circumstances for you to be granted bail, which is not exactly the condition if you're charged with an offense triable by the magistrate's court. So that might explain a bit of the differences in who is granted bail and who is not. But then again, I think there are deeper questions that the judiciary will have to answer, because I wouldn't say that all the politicians you're talking about from the other parties have actually been charged with offenses that are only triable by the High Court.
Yes.
Some of them have actually been charged with cases that are triable by the magistrate's court, but bail has been difficult for them to acquire. So there's a need to create some kind of consistency around how bail is granted in the country generally.
Okay, now speaking of the High Court, you know, overruling the decision of the Magistrates Court, just like we saw yesterday, doesn't that harm the integrity of the Magistrates Court in any way?
Not necessarily, because the court was exercising powers that are granted to it by the Magistrates Courts Act. If someone is granted bail and the person feels that the terms of bail are excessive, they can actually take a case to the High Court and ask that the High Court reviews the terms of bail that were granted. So it's an ordinary procedure of court. It's like appealing to court. If you're found guilty in a case, you can actually appeal to a higher court. So I don't think it affects the integrity of court. It is just the exercise of superior jurisdiction. The High Court is higher than the Magistrates Court, so they look at the decisions, and if they think the decision was unjust or carried out in error, they will go ahead and review that decision and change the terms. Not so much overrule, but change the terms.
Okay. In regard to that also, multiple people have talked about maybe the magistrate was actually emotional when they were awarding these bail terms. Would you think they were emotional in any way?
I mean,
or they're actually doing it right? I
can't speak to the state of mind of the magistrate, but certainly if for an ordinary person, the 30 million always looked like it was an excessive amount of money. And the court agreed with that, because if you look at the nature of the offense that Dr. Kizza Besigye was charged with, incitement of violence, it is not the kind of offense that raises to that level, because we've seen lower bail terms actually set for offenses like murder, even offenses for acts like terrorism. We've seen actually lower terms of bail set by the High Court. So if the Chief Magistrate goes ahead and sets terms whereby the securities are supposed to be paid is 30 million, it always seemed like it was excessive. And I think court judicially exercised their powers to reverse that decision. Also, still in light with
Dr. Kizza Besigye being granted bail, even while his bail terms were still processed, he talked about, I will still go on with the protest. So in this regard, I would want to know, does he still deserve bail even after he goes on and protests again? Doesn't that even affect his bail terms in any way?
I don't think it does, unless, because I don't know if what he's engaged in is actually is an actual offense. But the issues normally that court looks at when it's looking at bail are issues like, will you affect the evidence in the case? Will you affect witnesses? Is it likely that you're going to be charged with another offense of a similar nature and you may run away from the country? Those are the kind of things that court looks at. But if there is no sort of conviction
at the moment,
so he's still presumed innocent. So court cannot rely on statements he's made to actually deny him bail unless those statements are criminal in nature. So
isn't it criminal though? Because I mean, protest, if it's done not under the law, then it's definitely criminal.
Protest by its nature is not criminal because we have in this country the constitution recognizes the right to assembly and association. So protest is a form of assembly. So unless you engage in criminal activity during that protest is when it becomes a crime. But going to the street and having carrying out an assembly, a procession in form of protest is not a crime in Uganda. It is when you go ahead and engage in criminal activities during the course of that protest is when it becomes criminal. So it's not a crime, regardless of how at times it has been treated in Uganda.
Yes, now you've talked about it's actually not a crime, but right now we see Doreen Nyandura, and that is the Deputy Lord Mayor of Kampala, and also the woman member of Parliament of Soroti, and that is Miss Anne Adeke, are still behind closed bars because of, protesting about the detention of Dr. Kizza Besigye and also the high commodity prices. They did not commit any crime, but they were protesting. And if it's under the law, why were they detained?
That is still a good question for the police to answer. Maybe they are privy to certain forms of evidence that I am not privy to as an ordinary person. Maybe the police know something that we don't, and maybe they relied on their intelligence as well as tell us to arrest those honorable members of KCC and Parliament for protesting. But if it is just about protesting ordinarily, that should not be a crime.
That's what it was.
Unless they have evidence that a crime was about to be committed, or the two people were in the process of committing a crime, or that their possession at the time turned riotous, or they engaged in criminal activity during the course of their protest. Then police can go ahead and arrest them, and maybe they'll be able to tell us better if they have evidence to that effect. Okay,
now also would like you to give us an insight in regard to, having been given or granted bail and then being rearrested, just like we have seen in multiple cases with Dr. Kizza Besigye. So in that regard, doesn't that defile the aspect of bail and, the terms and the rule of law involved?
I think the rule of law, terms of bail, were really restored by the High Court. When the High Court reviewed the decision, I think they really judiciously exercised their authority as the High Court to review that decision. And I think that gives the public confidence that even when there is an error or a perceived error by a member of the lower bench, the higher bench has the capacity to exercise justice. So I was very happy with the decision that was reached, because regardless of your politics, you don't have to be someone who believes in the politics that is being that Dr. Kizza Besigye is engaging in, but these are really issues of rule of law. So we don't want to see a scenario where rule of law goes to the dogs. So I think the general public will generally be happy that even when there is an error by another judicial officer, the judiciary has the capacity to correct that error within the judiciary itself. So I think it's good for rule of law.
Okay, still, I mean, we are really exhausting the concept and aspect of bail. Yesterday, when he was granted bail, even then he was still bundled up into a van, because we believe that after being granted bail, you should be, left to go as a free man, as a free woman. So could the court, intervene, because he was being bundled up again and put in a van, I don't know, take him back to his home? Yes.
Yeah, I mean, those are the kind of scenarios that become very difficult to properly analyze, because court has made a decision, and as Ugandans we all ought to respect the decisions of court. So I don't know, police should be able to answer some of those difficult questions, because if someone has been granted bail, I think as police you should only be able to rearrest that person or deprive them of their liberty, even if it's not an arrest, or deprive them of their liberty if they engage in another activity that you deem to be a crime. But maybe, like again I said, maybe police knows something that we don't.
But in that case, we would think that court would intervene, because he hasn't done any kind of protest at that moment. So yes.
Court can only intervene when you take the matter back to them, because court relies on law enforcement as well. So court deals with matters that are properly before it as the courts of law. So if that matter is taken back to them properly as the courts of law, they will be able to deal with it. Court cannot deal with a matter that is not taken to it, that is in the general public. So if Dr. Kizza Besigye goes back to court over those issues, then court will be able to hear the issues that arise out of that and reach a decision. So I don't think court, no, they do have the capacity to do something about some of those acts that they may deem improper, but they can only do something about them if those questions are presented before them. And I don't think those questions have been presented before them as yet.
Yes. Well, last year, President Yoweri Museveni did talk about that some criminals in this country do not deserve bail. And he did highlight that some of them are terrorists, those who are, accused of crimes of terrorism, and also murderers as well. What would you have to say about that? Would this require constitutional review in any way?
It would, but under our current law, everyone has the right to apply for bail. But like I said, the right to apply for it doesn't mean that you automatically get it. You still rely on the discretion of court. And for cases of, for instance, terrorism and murder, those are only triable by the High Court. So the circumstances, court says it can only grant you bail if you prove exceptional circumstances for cases of that nature. So I think even without engaging in any amendments, I think that is an issue that court can properly handle. If they think you've been charged with a crime of murder or terrorism and there is a high probability that you're going to be found guilty, and then they also think you don't meet the exceptional circumstances that they think you should meet for you to be granted bail, they can actually deny you bail. There is nothing in the law that says that if you apply for bail, the judiciary or court has to grant you bail. Court has to look at a range of circumstances to determine whether or not they should grant you bail. So if they think the circumstances don't raise to the bar where I should be granted bail, then they will deny you the bail. So I don't see where all the noise around bail is. I think I've not heard complaints from the ordinary public regarding bail, and people saying that maybe bail is being abused by the judiciary. Judiciary is excessively granting bail. I don't know, but maybe the president, who is privy to a lot more information than I am, knows quite a number of things that we don't, and maybe he has commissioned some studies where he has found that really there's a problem with bail and it's affecting the public, because he has previously talked about things like granting bail ordinarily leading to issues like mob justice. Maybe he has reports to that effect that actually can link some of those practices to the High Court poorly granting bail to people that don't deserve it. Okay. But as things stand, I think the law is sufficient.
Sufficient enough, you would say?
It's sufficient enough.
Okay. Okay, in regards still to bail and, Dr. Kizza Besigye being granted bail, he wasn't granted access to his vehicle. And until today, people are talking on social media demanding that they should let him have access to his vehicle. So when an individual is granted bail, and they're supposed to have access to their belongings if they have been confiscated by law enforcement officers?
Yeah, certainly they should have access to their belongings. Maybe the process is, the court is still in, the police is still in the process of processing his belongings and giving them to him. Maybe we can give them time. Since the bail was granted yesterday, maybe they are processing the belongings and we'll give them back to him. I think if he doesn't get back his car within a reasonable period of time, he still has the right to run back to court and say, look, police is illegally holding my car. I don't know the reasons. I've not been granted the reasons as to why that is happening.
Okay.
Yeah.
In your opinion, would you say, you have said that the law is sufficient in this country, but would you say that justice is actually sufficient in this country? And the reason I say this is for the fact that until this day, multiple leaders in the opposition, I'll talk about Mohamed Segirinya, is still, in prison, and they haven't been allowed bail until this day. And also we talk about Doreen Nyanjura as well as Anne Adeke. Don't you think justice is being delayed and denied in this country?
I think there are certainly issues around how cases of a political nature are being handled by the judiciary, and that is something ultimately they'll have to look into, because people want to get the feeling that there is fairness and consistency in how the judiciary, with the speed and how the judiciary deals with cases of this nature, because it's not all cases, incidentally. It is cases of a particular nature, those ones that are allied to politics or that are linked to politics, that have those problems. So I think the judiciary needs to go back and really have a critical look at themselves and determine that really they should have a bit of consistency around how they hear different cases, around the issues of terms of bail that we've been talking about. Create some consistency. I think consistency is the only problem, because the law is sufficient, but the law relies on judicial officers who exercise the right to determine what the law is for us. So we just need consistency around how they interpret the law and apply the law.
Yes.
So that is something they should do internally and create a bit of consistency, such that people don't have a feeling that there are other people who are being victimized, because that's now the feeling that is in the general public,
Yes.
that there's a bit of victimization.
Yes. Would you, however, strongly affirm that the judiciary is actually independent in this country at the moment?
I think that is something the judiciary should be telling us, whether or not they're independent. But
Yes.
from a constitutional and normative perspective, yes, the laws of Uganda provide for an independent judiciary, and the judiciary, the manner in which they are appointed, and the manner in which they receive their emoluments, the protection that they are granted when they sit as judicial officers, means that they should actually be independent, because judicial officers have a lot of immunity when they sit as judicial officers. In fact, you cannot prefer a suit against a judicial officer for a decision he reached as a judicial officer. So they have a lot of protection and clout when they sit as judicial officers. So that should be able to give them enough independence in the course of carrying out their work. So what I can say is, in terms of the legal framework that we have in Uganda,
Yes.
the judiciary is an independent arm of government. Whether or not they are able to exercise that power independently is a question only they can answer. But the public out there may also have its own perception of whether or not the judiciary is acting independently based on the decisions they reach and how they reach those decisions.
Okay, that was very unrelated. It was a personal question. But anyway, as we wrap up the conversation, I'd like to know from you, in the event that the defendant doesn't agree with the bail terms, in the case of Dr. Kizza Besigye, after his bail terms having been eased from 30 million to 3 million, if he had said no to the 3 million Uganda shillings, what would we have expected as Ugandans? What would have happened, or what would happen?
What would happen? The option would be he either stays in or he looks for another remedy for reducing the terms of bail. But
Yes.
the court had done its work. So he had those two options. Yeah.
Okay, finally, as we wrap up the conversation, would like to get your parting shots or any takeaway that you would give a Ugandan or a viewer out there in regard to bail terms and bail practice in Uganda?
I think my parting shot would be, really, in Uganda, application for bail is a constitutional right. So when you're charged with a criminal offense and then you're remanded or you're about to be put in remand, you can always apply for bail or go through your lawyer to apply for bail.
Yes.
And the chances are that if you meet the standards, of bail, the courts will actually grant you bail, because there are so many people in Uganda who have been granted bail. I think it is those exceptional circumstances which we are now discussing where courts have not granted people bail, but normally people actually granted bail. And I was happy with the decision yesterday, personally, from a legal perspective, because we don't want to create a precedent where bail is being used as a punishment, because there's actually a court decision to that effect saying that
Yes.
bail should not be a punishment, shouldn't use it to penalize the person applying for it. So the standard of bail should not be high to ensure that the person who is applying for it cannot meet those standards. So I was happy with the court going ahead to review the decision of the lower court and say, look, I think the magistrate may have erred in law by reaching this decision, because we feel this may not be a just decision given all the circumstances and the nature of the offense.
Yes.
So on the whole, I think the judiciary performed well, and I think the public will have a lot more confidence when they go before judicial officers. So that's a good thing.
Yes.
It was a good highlight of the day. Yeah.
Okay, thank you so much for that input. It's very much appreciated, and I do think for sure that a viewer out there has, you know, understood how bail comes about in Uganda, and that it's actually their constitutional right to apply for bail. Well, that has been Counsel Eric Namungalu, who is a human rights and a constitutional lawyer as well, weighing in regard to practices of bail in Uganda. And that winds up the conversation that we had for you on Twitter Jabs too. But keep watching Sunrise at Sea and don't blink.